About that next, who you got over there?
Good afternoon, Your Honor.
Hey.
I have, position 1 and 2, Kenyatta Bishop.
Okay. We can go ahead since is Ms. Cole here?
I don't see her.
Mr. Lang, y'all know where Ms. Cole is?
I do not, but I can with a quick phone call. Give me 1 minute.
There's a couple of cases. One, Miss Sampson has it, and the other one, Miss Cole has it. So I'm not sure who's going to handle it. All right, so Miss Pinto's talking there. Cases. Let's see. Let's see. Clarence Brinson, if you're in one of the booths, wave your hand. All right. Mr. Lang, you want to go ahead on position 9, Clarence Brinson?
Didn't he go just make a phone call?
Oh, yeah, I just think he did. Hold on. I don't know if it's rowdy.
Your Honor, I just got off the phone with Ms. Cole. She stated that position 3, Tritavia Sorrells, was released.
Yeah, but she's got another one. That's the
Position 1, Kenyatta Bishop. She said Miss Sampson filed entry and is handling both of those positions.
okay. I don't see Miss Sampson here either, but thank you. All right, well, we'll start with yours. How about that? Clarence Brinson?
We can do that.
All right. Position 8, pretrial 22, TP 210885. Clarence Brinson, 97 days without indictment, no bond as of July 31st. July 23rd. Tampering with evidence, felony, possession of a non-foreign firearm during the commission or attempt to commit certain felonies, possession of drug-related objects, purchase, possession, manufacture, distribution, sale of marijuana. Pre-trial.
In regards to Mr. Brinson, 10 prior arrests, open case, 21 CP 1967763. Marijuana with the intent to distribute firearm during 22 CP 207551. Possession of marijuana and tampering with evidence. He's on 2 first offender probation. 2 steps by receiving. The other one is manufacturing marijuana with the intent to distribute, obstruction. Sentence 12819 for 5 years. Nothing further.
Mr. Lane, go ahead.
Yes, Your Honor. First for Ayala, Mr. Brinson is 22 years old. He has 1 child, 11th grade education, was working in landscaping at the time of his arrest. He's a lifelong resident of Atlanta, lives at the address on file with his mother. As Your Honor heard, he's been in custody since July 23rd on a no bond. I made the argument at first appearance, it was denied, but I will bring it to the court's attention again that the tampering with evidence should be a misdemeanor. The statute states tampering in one's own case is a misdemeanor charge, tampering in another's case is a felony. The warrant alleges he tampered in his own case, therefore it should be charged as a misdemeanor, not a felony. Based on the information presented, I am asking the court to set a bond based on both the length of time he's been in custody and the error in the charging in this case. Based on the charges we have, I would ask the court for a $5,000 bond in the possession of a firearm during the commission of a felony. Bond not to exceed $5,000 on the marijuana, and then I would ask for a UJR on the tampering and the drug-related objects for a total bond not to exceed $10,000 split.
All right, what says the state? Mr. White?
You're muted, Tom.
Got to unmute myself. Judge, given the underlying facts of this case and the fact that I agree with the defense counsel, tampering with evidence in your own case should be a misdemeanor. It is a misdemeanor and should be a misdemeanor. The defense counsel's request is not unreasonable.
Okay. You going to do something, you can reduce that to a misdemeanor, but what about the rest of them? Looks like he's got...
Judge, I don't think, I think that every piece of the defense counsel's request was reasonable in this case.
Give me some numbers, Mr. Lang.
Your Honor, I believe I said 10K split, 5 on the gun, not to exceed 5 on the marijuana. Usually I ask for 2 on that, but I know the scheduling order has its own issues. So I'd ask the court to do 7,000 split, a 5 on firearm, 2 on marijuana, UJR on tampering, UJR on possession.
All right, so right now, is just one thing that bothers me, that there's an open case where the offense date was 1/13/2021. There's another one of 3/18/2022, and then this one is 7/22/22. Where's he gonna live, Mr. Lang?
He's going to live at the address on file. Let me get that for you.
You got Lorenzo Drive?
Yes, Your Honor, going to live at that address with his mother.
All right, no drugs unless prescribed, no alcohol, no weapons. You're gonna have an ankle monitor paid for by the county. You can only have the 24-hour curfew for court and lawyer. Any other exceptions, Mr. Lang, you're asking for?
Employment, Your Honor. He was working with landscape, and I don't have the name of the company, but I know it was a full-time position, and he'll be able to do it.
Okay, employment, as long as he can supply the name of his employer, schedule, and exactly where he's going to be working. Stay away from 850 Oak Street Southwest. That ankle monitor is going to be paid for by the county. Let's see. Count 1, UJR through the jail. Let's see. Hold on a second. The other one's both. Yes.
I'm sorry, should I reduce that tamper with evidence or no?
Are you going to do, Mr. White, you going to sign something to reduce it to a misdemeanor?
I don't believe so at this time, Judge. I believe, no, we can just leave it where it is for right now for purposes of this hearing.
All right. How about we just make that, we'll make that, yeah, UJR through the jail, leave it as a felony. It's easy. And you can put on there that the state didn't happen to mention that it should have probably been charged as a misdemeanor. But the thing is that the other couple of cases, he's always had a gun. So we're going to make that 10 on the gun and 4 on the possession, manufacture, distribution of marijuana. Best of luck to you, sir.
Your Honor, drug-related, UJR?
Oh, yeah. Drug related is a UJR too, through the jail.
Thank you, Your Honor.
Yeah, you
Yeah.
said 4K on the possession.
Yeah, 1K. Right. 4K. Sorry.
4K. Okay, thank you, Judge. I'm sorry.
That's okay. All right. Let's see. Do we got Cobb back? We got Cobb back.
Can you hear me, Judge?
Yes, ma'am.
Okay, good. I was on earlier, but my mic wasn't on. My apologies.
Oh, that's okay. So let's see. We got Cobb back. And that is, hold on a second.
Real quick, Your Honor, just Mr. Brinson's still sitting there. Mr. Brinson, you got a 14K split bond, so your family can get you out for around $1,400. But your bond is set. You're good to go. You should be able to leave the booth now. I'll get in touch with you if you can't make that, and we'll figure out where to go from there, okay?
All right. Cobb, booth 3. That's Quentin Jones, position 8, pretrial, 22 CP 210856, 99 days without indictment. No bond as of July the 23rd on possession of firearm by a convicted felon, reckless conduct, except by receiving stolen property. Pretrial.
Judge does not qualify for UJR to pretrial services. Multi-state offender, Tennessee 17, Florida 15, Georgia 1. Currently on first offender probation for aggravated assault, 2 counts, terrorist threats. Sentenced in 2019, 1 year confinement, 4 years probation. 19 SC 170025. Misdemeanor battery in 2022, 2 FTAs, 3 arrests for probation violation. Nothing further.
Sound better. Sound like you feel better tonight. Pretrial. Thank you. Go ahead, Ms. Pinto.
Thank you, Judge. Mr. Jones is 38 years old. He is originally from Miami. He had recently moved to Georgia. He's been here about 7 months. He was living at the Faith Project, which is a halfway house, at the time of his arrest. He does have both a hold for a federal case and a hold for the first offender probation that was mentioned by pretrial. He has seen no movement on this case. You know, it's been 99 days with no indictment. He has seen no movement on his alleged probation violation. And given his status, his inability to pay bond, and the fact that he has this federal case looming over him, which is obviously very serious, we are asking the court to do a UJR to that hold. While he's been in jail, he has taken advantage of the IT fundamentals course, and I have a certificate from him showing that he completed that course. So he has taken advantage of what's available to him. Of course, he is entitled to a bond judge, but we are just asking that it be a UJR so that he can handle that federal case, which is, of course, of great concern.
Where's he going to be living
Well, he would just go, well,
afterwards? You have any idea?
afterwards, let's see. Well, it's a family friend who runs the Faith Project. So the goal would be to get him back into there. And he also has a job through her as well at Anderson Construction. So
Sure.
when he does eventually get out back into the world, hopefully he can return to that job.
All right. So you may have noticed on Odyssey, there's 2 warrants out there from 2015. Both of them are robbery. One in June of 2015, one of November of 15. Just for your own edification, so you'll know.
I did not
All
know
right.
that, Judge.
What says the state?
Judge, the state notes that the current known address of this, or the address on record for this defendant is homeless. Therefore, if he is released, he will immediately put in digital hold status, having no verifiable address. Effectively, then this case will be put in permanent limbo. Judge, UJR is not even eligible. This is not a case that's even eligible for a UJR. The state would request a bond of not less than $100,000 on the possession of a firearm by a convicted felon, not less than $1,000 on the reckless conduct, and not more than $500 on the theft by receiving stolen property.
All right, Ms. Pinto, do you want the EW numbers for those 2 warrants?
Yes, Judge.
EW 147083 and EW 0159617.
Thank you.
All right. All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 929 Lee Street Southwest. No further contact with Robert Jones. No further contact Fernando Della, Dela Rosa, Rosa. Stay away from 3070 Garnett Way in College Park. 25,000 on count 1, 1,000 on count 2, and 500 on count 3. Best of luck to you, sir. You can lead the booth.
Thank you, Judge.
Ms. Sampson, so South Annex, Kenyatta, Bishop.
Judge, you didn't say ankle monitor, so I just want to make sure before we go on.
Yeah, ankle monitor paid for by the county, but he'll have 48 hours after he gets released to have that placed on once he gets off his hold. So he'll have he can leave for court, see his lawyer.
Thank you, Judge.
All right. Kenyatta Bishop, position 1 and 2, pretrial, 22 CP 211520, 93 days, $1,500 good bond on theft by shoplifting as of August the 17th. Position 2 is 22 CP 211025, Kenyatta Bishop, theft by shoplifting, $3,500 as of July the 28th. Pretrial.
In regards to Ms. Bishop, 7 prior arrests, does not qualify. A couple of convictions this year, 2022 battery and theft by shoplifting, theft by another case, theft of services, criminal trespass and obstructions on 12 months probation. And 2021 convictions for felony theft by shoplifting, theft by conversion have a hold in Cobb County. Nothing further.
All right. Ms. Sampson, go ahead.
Yes, Your Honor. In August, I applied for her to be accepted. I sent a referral over to accountability court in order for her to be interviewed. The problem is that she doesn't qualify for their service at this time until the Cobb hold is taken care of. So this time I'm asking for her to get a signature bond to the Cobb hold so that she will be able to be interviewed by accountability court. I think she will actually qualify for their services after that hold is taken care of. As you already mentioned, she has a bond of $5,000 that she clearly cannot afford, Your Honor. And Bell Project, they do not cover bonds where people have holds.
All right. So I have on one, she had a Woodstock address, another one, she had a Lithonia address. Ms. Sampson, where's she going to be living?
The Lithonia address.
All right. What says the state?
Judge, the state notes that apparently the Cobb offense is also a shoplifting offense. I don't know what the reason is that was given, but it doesn't look like she would qualify for accountability court due to the aggravated assault conviction in any case. Judge, when this defendant is eventually released from custody, it's not a question of if, but rather how many hours it will be before she shoplifts again. There's been no change in circumstance, Judge. There is no reason to disturb the bond as is.
All right. So, position 1, no drugs unless prescribed, no alcohol, no weapons. Stay away from 3393 Peachtree Road. That's stay away from Lenox Mall. Stay out of Fulton County unless you're here for court or to see your lawyer. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, and obviously if you've got something probation on another county you've got to go to, you can do that. I'll reduce this to a $750 good bond. On position 2, no drugs unless prescribed, no alcohol, no weapons. Stay out of Fulton County unless you're here for court or to see your lawyer. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court and lawyer. And if you have any probation officers you got to go to, you can go see them. Stay away once again from 3393 Peachtree Road. That's Lenox Mall. Also, stay away from 1468 Holcomb Bridge Road in Roswell, and stay away from all Shell gas stations. But stay out of Fulton County. Don't even come here for gas unless you got here to see your court or to go see your lawyer. Reduce this to a $1,500 good bond. Best of luck to you, ma'am.
Your Honor, if she gets into accountability court, because there's a MH issue. So if she gets in accountability court, that means she'll be living in Fulton County.
I can check with them that she could live there if she's living there in some sort of facility. I can modify it there. And you can send it to me with if she gets accepted.
Okay, thank you. That concludes my business. May I be excused?
Yes, ma'am. Thank you. That's it, right, South Annex?
Yes, Your Honor, thank you.
All right. See you, South Annex. Have a good one.
You too, bye.
All right. I got Rashad Foley. Wave your hand. Mr. Foley, there we go. Position 5, 6, and C. There's 3 cases. Pre-trial.
4, 5, 6.
Yeah. Let's see. Oh, position 4 was indicted today, or the 20th.
Yeah, that number is it 22 SC 184742.
Yep. So we're just looking at 5 and 6. Position 522 CP 210848 Rashad Foley, 98 days without an indictment, driving, fleeing, attempting to elude 30-year-old right away. No bond as of July 22nd, 2022. Position 6 is 22 CP 210849 Rashad Foley, 98 days without indictment, no bond as of July 22nd, fleeing and attempting to elude, used for DUI, reckless driving, possession of marijuana less announced, cruelty to animals, and obstruction of a law enforcement officer. Pre-trial.
Judge, Mr. Foley, 10 arrests in Georgia, 5 in Louisiana. Open case, 19 SC 166673, charge related to CWAC. Assigned to Judge Krause, same charge, 22 SC 184742, as I just mentioned. The underlying CWAC charge was in 2012 and convicted in 2017 for a charge associated with CWAC. 4 prior arrests for probation violation, nothing further.
All right. What's up? Go ahead, Ms. Pinto.
Thank you, Judge. Mr. Foley is 32 years old. He's lived in Georgia since 2005, so a significant period of time. He is from New Orleans originally. If released, he would live at his mother's address at 150 Peyton Place Southwest, apartment 3208 in Atlanta. He plans to stay there until he can get a job, and then of course, get his own place. His 2 children are living with his mother, so he would return to them. She has expressed that she would like help with the children as well. So he does hope to he was working at Bennett Pools, so he hopes to be able to get a job doing that again. I believe they manufacture pools, if I remember correctly. He's also he has friends who work at MARTA who are going to help him try to get a job there as well. He has 2 years of college. He went to Westwood College for computer networking management. And he unfortunately was not able to finish that degree because Katrina disrupted his family life and his financial aid. He is, of course, entitled to a bond, Judge. He's been incarcerated for 98 days with no indictment on 2 out of his 3 cases. So we are asking the court to set a reasonable bond on these cases today, in the hopes that he can get out and return to his family and assist in his defense. I will just say, I know cruelty to animals sounds bad, but it was a misdemeanor, and the dog is fine and has been adopted and is doing great in Florida, just in case the court is concerned. As we are asking for, as I said, a reasonable bond of $5,000 on each case.
All right, what says the state?
Judge, the state notes that there are mandatory minimum confinement sentences on the fleeing and attempting to elude. Therefore, this defendant is looking at a substantial time in an incarceration upon conviction for either or both of these underlying offenses. Given that, and given his prior history of, what was it, 3 or 4 probation violations, there is a significant concern that he will flee the jurisdiction or fail to appear when required to do so. The state also notes that the cruelty to animals is a misdemeanor charge. The state requests a bond of not less than $100,000 on each of the 2 fleeing and eluding. As to position 5, an additional $1,000 on the failure to yield right of way. As to position 6, not less than $100,000 on the flee and elude. Not less than $5,000 on the reckless driving. Not less than $500 on the marijuana. Not less than $5,000 on the cruelty to animals, and not less than $100,000 on the felony obstruction.
All right, so position 5, no drugs unless prescribed, no alcohol, no weapons, no driving during the pendency of this case. Got to be on a 24-hour curfew except for court, lawyer. You ask for something, employment, as long as he gives the name of his employer, the location he'll be working, and his schedule. That has to be turned over. That ankle monitor will be paid for by the county, and he has to keep his address updated. $50,000 on fleeing, attempting to elude, $1,000 on failure to yield right away. Position 6, no drugs unless prescribed, no alcohol, no weapons. You can't have any animals or any pets. You got an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, employment, as long as you get the name of your employer, the location you'll be working, and a schedule. You have to give that, sir, to both your lawyers. You can turn it over to the state and to the ankle monitoring company, so they'll know where you're at. Absolutely no pets. And I think on the other count, on the other charge that they just indicted, there's no bond. So no matter what, sir, you can't get out, because the other case that was pending has been indicted and a bond has not been established for that. $50,000 on count 1, $5,000, $500, $5,000, and $50,000. $50,000, $5,000, $500, $5,000, $50,000. Got that? Ms. Parham?
Judge, Judge, I was trying to unmute. I did. On the first one, on the first fleeing and attempting, was that 50 also? I thought you said 15.
Yeah, 50, 50.
Oh, okay, thank you, Judge. I got it. Thank you.
All right. Thank you, sir. You can leave the booth. All right, Ms. Pinto, you got Marcus Boyd. Marcus Boyd. Marcus Boyd, wave your hand. You see him?
I don't, Judge, and he is currently, I think, being restored by DBHDD, so I'm not sure. I mean, I think he's still entitled to a bond. However, I'm not sure if the jail has been able to bring him for this. Oh.
Marcus Boyd, are you there?
Judge, there's a chat message. I reached out to Lieutenant Barry regarding Mr. Boyd. He said that he's trying to make contact with 3 North to have.
Okay, have him move. Oh yeah, you invited that other booth, right?
Mm-hmm. Yes, I did.
Okay, all right, so we'll come back to him, see if he gets him in there. All right, Marvin, let's see, Marvin Bailey. All right, this position in Mr. Lang, 22 CP 210707, Marvin Bailey. There's a $52,000 bond as of July 16, 2022, 105 days with no indictments. Theft by receiving stolen property, felony, giving false name, address, date of birth to law enforcement officer, expired license on persons. Pretty Trial.
Judge, Mr. Bailey, 24 prior arrests, 2 FTAs, 20 and 22, currently on 2 separate probation, 1 aggravated assault, battery, family violence, 21 SC 179741. The other one is for aggravated assault, 21 SC 178899. Sentence on the same day, 1/27/22. 2 years confinement, 3 years probation. Nothing further.
All right, go ahead, Mr. Lang.
Yes, Your Honor. For Mr. Bailey, hold on one second. Here we go. Mr. Bailey is 34 years old, born and raised here in Georgia. Would be living on Peachwood Circle in Atlanta, Georgia. He has 9 children ranging in age from 1 to 16. He got his GED in 2005. At the time of his arrest, he had been working for Fresh Express for a couple of months. As it goes to the bond, we did speak with Mr. Bailey. He was referred to a sober living program through Grady. We believe upon his release, we'll be able to get him into that program and start getting him some help for some of the issues that are presenting through his criminal history. In this case, while I understand the things we heard about that he was on probation for, this itself is a nonviolent case. There are no allegations of violence or threat to the community in this case. I understand the argument can be made for threat to property. But based on the information presented, he's been in custody since July on a $52,000 good bond. He's obviously unable to afford that. I'm asking the court to substantially lower that bond at this time based on the amount of time in custody without indictment. I'd ask the court to set a $5,000 bond on the theft by receiving stolen property, $1,000 on each of the 2 misdemeanor charges for a $7,000 total good bond.
What says the state?
Judge, the argument of defense has shown no material change in any circumstance. The state would object to any reduction in the amount of the bond. The state would request that if or that a special condition of the bond when he is eventually released be that he absolutely not operate a motor vehicle.
All right.
Also that he no firearms is a given, but yeah, that he absolutely not operate a motor vehicle under any circumstances.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Jerome de Guzman, Deguzman. No driving during dependency of this action. Stay away from 3120 Martin Luther King Jr. Drive. You're going to have an ankle monitor with a 24-hour curfew. You can leave your house for court or lawyer. Anything else, Mr. Lang? I mean, he can't drive.
We're still going to have to figure out work, but I know I'm going to have to get where he's working and all that first.
Okay. I mean, he could go for work. He's just not going to be able to drive for work, but he could go there as long as he puts in, so he can leave for employment, but he's got to put in the name of his employer, location, and a schedule given to the ankle monitor company and to the state. All right. So 35,000 on count 1. Count 2 and count 3 are already 1,000 apiece. So we'll reduce those to 500 each, 35,500 and 500. Best of luck to you, sir. You can leave the booth. Tobias Thompson. All right, down there. Sorry, you got to put your head down there so far, sir. Position 11, pretrial 21 CP 203175. Tobias Lamar Thompson. 402 days. There's been reasons there, but this is a $25,000 split bond on aggravated assault with intent to murder, willful obstruction, and reckless conduct. This was set in March of 2022. Trial.
In regards to Mr. Thompson, 12 prior arrests, 5 misdemeanors, 3 FTAs, 18, 19, and 20, 1 arrest for probation violation, 1 misdemeanor conviction is a 2018 battery. Nothing further.
All right, go ahead, Mr. Lang. And last I had, he lived in Marietta. And this incident date was 9/21/2021.
Correct, Your Honor.
Okay.
Is still going to be living at that Marietta address. He's 22 years old, lived his entire life here in Georgia, was born at Grady Hospital. He completed his GED in 2015. At the time of his arrest, he was unemployed, does not have any children. Since he has been in custody, at the time of his arrest, he was on a probation. Since he's been in custody, that probation has ended. He is off of that probation now. I understand based on the nature of the charge, one of the things I do just want to point out, even though it is charged as ag assault with intent to murder, the allegation is that a firearm was pointed at another individual. We see plenty of ag assaults come through here that are not charged with that intent to murder, that have even more aggravated and even more intent to murder details behind them. So I'm not sure why this one specifically got that tag. Nobody was physically injured. Nobody was shot. The firearm was never discharged, just as that goes to the mitigation of the charge. As for bond, as Your Honor stated, it's currently a $25,000 split bond. I would ask the court to lower that to a $12,500 split bond. Cut it.
All right, what says the state?
Judge, the state notes that the state has had no contact with the victim in this case. The defense has shown no significant change in circumstance that would merit a reduction in the bond. The state objects to any reduction in the bond at this point.
Your Honor, if I may, very briefly.
Sure.
I think the change in circumstance would be the 7 months my client has stood in custody without indictment, the multiple young men who have been assaulted and murdered within the Fulton County Jail while waiting for their cases to be indicted, the number of young men who have not had proper access to medical care while waiting in the jail to be indicted, and the intense financial strain this has had on my client and his family while waiting for an indictment on charges that are, if they're so severe, could have been indicted months ago. My client has been in custody for over a year, could have been indicted within a month.
Yeah, it looks like 402 days without indictment. All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Verna, B-E-R-N-A, last name Bair, B-A-I-R. Stay out of Fulton County unless you're court, see your lawyer. You have an ankle monitor paid for by the county. You leave for court, lawyer, and work as long as you put in who you work for, your schedule, and the name of your employer and the location that you'll be. You don't stay out of Fulton County, though. Don't come here for gas. So we'll do 15,000 on count one. Counts 2 and 3, another judge has already put UJR through the jail, so I'll leave those alone. Best of luck to you, sir. Stay out of Fulton County. What about Craig Walker? Craig Walker. There you go. Got 5 cases, looks like. Pretrial position 12, 22 CP 211593. Escape custody or confinement, 90 days with no indictment, no bond as of August the 20th. Position 13, 22 CP 211076, 90 days without indictment. As of July 30th, no bond on terroristic threats felony. Position 14, 22 CP 211075, 90 days without indictment. As of July 30th, no bond, interference with government property, willful obstruction of law enforcement officers. Position 15, 22 CP 211074, 90 days without indictment. No bond as of July 30th. Possession of firearm by a convicted felon, aggravated assault with a deadly weapon. Position 16, 22 CP 211073, 90 days without indictment. As of July 30th, there's no bond on terroristic threats felony, possession of firearm by a convicted felon, and aggravated assault with a deadly weapon. Trial.
Judge, in regards to Mr. Walker, he has multi-state offender, 11 in Florida, 15 in Georgia. He has 4 felonies in Florida, all been drugs and 1 robbery. In Georgia, he has 5 other open cases, 1 misdemeanor, 21 CR 00235C, battery, visible, substantial harm, 22 CP 211091, interference with government property obstruction, 22 CP 212456, aggravated assault, 22 CP 211202, aggravated assault, criminal damage to property, 21 CP 199673, aggravated assault with a deadly weapon, firearm during and simple battery. Nothing further.
Thank you, pretrial. Go ahead, Mr. Lang.
Yes, Your Honor. First, I want to address this. Mr. Walker put his hand up during his history. We are working on, we believe there are a number of things in his history that are attributed to him that were committed by another individual who's been using his name. So we're trying to sparse all that out. I don't have details as to what specifically should be his and what should not be his right now, but we believe that a majority of that criminal history is not actually attributed to him. For Ayala, Mr. Walker is 31 years old. He's lived in Georgia for the last 17 years of his life. He lives in Atlanta, Georgia at the Plaza Lane address with his father and stepmother. He completed his GED in 2010 and then 1 year of college while studying criminal justice. He was working with the People Ready Temp Agency at the time of his arrest. I know that company pretty well. He'll be able to go right back to working with them upon his release, and then they'll find positions to put him in based on their different assignments. I understand there's a lot of cases, so I understand the bond will be high in the aggregate. Because of that, I'm asking for decently low bonds on each case. On position 12, I'm asking the court for a $7,500 good bond. On position 13, I'm asking the court for a $5,000 good bond. On position 14, I'm asking the court for a $5,000 good bond, $2,500 on each. On 15, I'm asking the court for a $10,000 good bond, 5 on each. And on position 16, I'm asking the court for a $12,500 good bond, 25 on the top charge, 5 on the remaining 2. That's based again on his criminal history, the IALA factors, and the amount of time he's been in custody without indictment.
All right, what says the state?
I judged this is a danger to the community, a danger to everybody around him, and likelihood to commit additional felonies when he's eventually released from confinement is close enough to 100%. I wouldn't bet against it at all. On the other hand, I have no idea why this isn't indicted. On the escape from confinement, Judge, the state would request, on position 12, the state would request a bond of not less than $100,000. On the terroristic threats, request a bond of not less than $10,000. On the interference with government property and the felony obstruction, the state would request a bond of not less than $50,000 on the interference, and not less than $100,000 on the willful obstruction. The state would note that this defendant, I can't remember which of the 2 aggravated assaults, ended up shooting his victim multiple times. Would request a bond of not less than $50,000 on the possession of a firearm in 15, and not less than $250,000 on the aggravated assault. On position 16, would request a similar bond with an additional $10,000 on the terroristic threats. Strict 24-hour house arrest. He can leave if medical emergency carted away in an ambulance, or if he has to actually attend an in-person hearing in court. Other than that, electronic communication is a great way to talk to your lawyer. I don't know what kind of work he thinks he does, but he's too dangerous to be out on the street at all. Nothing further.
All right, position 12. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor with a 24-hour curfew except for court, and see your lawyer. That'll be paid for by the county. And he's going to live in Atlanta, right?
Correct, John.
County. All right. $75,000 good bond on that. Position 13. No drugs unless prescribed, no alcohol, no weapons, no further contact with Randolph Scott. Patricia Harkness, Harkness. Stay away from 1995 Venetia Drive Southwest. No social media. And ankle monitor paid for by the county with a 24-hour curfew except for court, and see your lawyer. Medical, as the state said, in an ambulance. $15,000 on that. Position 14. No drugs unless prescribed, no alcohol, no weapons. You get a 24-hour curfew with an ankle monitor paid for by the county, court, lawyer, or ambulance to transport you to something medical. So I got 25 on interference with government property, 25,000, and 75,000 on the willful obstruction. Position 15. No drugs unless prescribed, no alcohol, no weapons. Stay away from 1993 Bent Creek Way Southwest. No further contact with Tracy Scott. Marquell, Marquell. Parks. No further contact with Zayima Scott. No further contact with Shanika, Sheneka Moore, Moore, and no further contact with Christopher Moore, Moore. That ankle monitor is going to be paid for by the county with a 24-hour curfew except for court, lawyer, and leaving in an ambulance to go seek medical attention. Possession of firearm by a convicted felon, 2,550 on the ag assault, 1,000. Position 16. No drugs unless prescribed, no alcohol, no weapons. You got that ankle monitor still paid for by the county with a 24-hour curfew except for court, lawyer, medical, leaving in the ambulance. No further contact with Tracy Scott. Stay away from 1993 Bent Creek Way Southwest. No further contact with Randolph Scott. 10,000 on the terroristic threats, 25 on the possession of firearm by a convicted felon. 100,000 on the aggravated assault with a deadly weapon. Best of luck to you, sir. You can leave the booth. Mr. Lang, I'll talk to you later, Mr. Walker.
Your Honor, can I make one request on this case?
Sure.
Can I ask the court to put it on a calendar within 30 to 60 days? According to Mr. White's comments, this should be an easy enough case to get indicted. When it's not indicted in a month or two, I'd love to revisit the bond.
All right. If you file your motion and so the motion's there, we'll make a note of it. Ms. Robinson and Ms. Francis, we'll get it back on there.
Appreciate it, Your Honor. That's my last case in front of you.
All right. Let's see. We got Dominic Smith. He'll come talk to you later, Mr. Walker. He's not going to talk to you now. He'll come see you and talk to you later. All right. Position 17, Dominic Smith. Dominic Smith, wave your hand. Okay, there we go. Position 17, pretrial 22, CP 210902. 98 days without indictment. No bond as of July 23rd. Got burglary in the first degree, false imprisonment, criminal trespass, and battery. Pretrial.
But in regards to Mr. Smith, 14 prior arrests does not appear to have any felonies, 5 misdemeanors, a couple of DUIs, and driving while license suspended. I think an aggravated assault was reduced for disorderly conduct in 2021 and 1 arrest for probation violation. Nothing further.
All right. That was in Judge Ed Lyon's courtroom. Okay. Go ahead. Let's see. Ms. Rosenover, go ahead.
Yes, Your Honor. Mr. Smith is 41 years old. He was born and raised here in Georgia, and he has a 12-year-old daughter. He recently did lose his apartment and his job due to being incarcerated, but I did confirm with his friend, Mr. Gerald Gardner, that he'd be able to stay with him. I don't know if the court would like me to just put that address in the chat once I'm done with this motion. I've also spoken with Mr. Smith's mother, as well as a former employer of his. All of them are very concerned about Mr. Smith and spoke highly of him. So he does have strong ties to the community. He got his GED in 97 and he served in the armed forces between 99 and 2001 as a medical specialist. He was stationed in San Antonio, Texas. He's worked a number of different jobs and wouldn't have any trouble getting a job if he was released on bond. And Judge, briefly with respect to the allegations in this case, Mr. Smith does maintain his innocence and he plans to defend himself in this case. Himself and the complaining witness do have a bit of a tumultuous history, to say the least. I personally have not spoken with her. I believe she may be on this bond motion. So I'll wait to see if she does make a statement, and I'd ask her a few questions if the court would permit that. But Your Honor, we just given with respect to the change in circumstances, Mr. Smith has been in custody for 98 days with no bond. He's willing to abide by any ankle monitor conditions or stay away orders that the court imposes. And given the fact that his family does not have the financial resources to post a high bond in his case, we would ask for a low bond, preferably a $5,000 bond, so he would be eligible for the bail project. Thank you.
So, Ms. Rosner, I know this, but so he pled in Judge Edline's courtroom on September the 23rd, 2021. And one of those conditions was to stay away from 1700 Riverwood Lane and not to believe it had no further contact with Miss Ledette. But let's see, Miss Ledette, would you like to say something? You're going to have to take yourself off mute and turn on your camera. Miss Ledette. All right.
I'm sorry, I'm available.
That's, okay. That's all right. If you raise your right hand for me, do you swear affirm testimony about to give the truth, whole truth, nothing but the truth?
Yes, sir.
All right. Let's see. Mr. White, you want to go ahead first, and then if either of you guys have questions for Miss Ledette, you can.
Miss Ledette, I believe someone from the district attorney's office contacted you earlier today, correct?
Nobody has contacted me. I haven't spoken to anyone.
Okay. I'm sorry, ma'am. I just have a note that somebody talked to you earlier today, so
No,
I apologize. Okay, are you opposed to Mr. Smith getting a bond?
no, I'm not opposed to it.
Ma'am, are you opposed to Mr. Smith having any further contact with you?
Yes, I am opposed to that. He is not to contact me ever again.
Okay. I believe those are the only questions I have, Your Honor. Thank you, Ms. Ledette.
All right, Ms. Rosenauer, do you have any questions for Ms. Ledette?
I will leave it at that for now, Judge. Thank you.
All right. No drugs unless prescribed, no alcohol, no weapons. You gonna be living in Roswell? Ms.
No,
Rosenauer?
Your Honor, he would be staying in Forest Park, Georgia.
Okay. All right, yeah, you can put in that address change into the clerk's office.
Yes.
Have that. All right, stay away from 1700 Riverwood Lane in Roswell, Georgia. Sir, not only is it a condition of your bond, it's also a condition of your probation in front of Judge Edline. They will revoke your probation and you will spend 1 year in jail if you continue to violate this allegedly. Stay away. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court or to see your lawyer. So you're also going to stay out of Fulton County. The only reason you're going to come back to Fulton County is court or to see your lawyer. No further contact. Absolutely no further contact, sir, with Karen Ledette. Karonledet. Ma'am, he's been in jail with that indictment. He's statutorily allowed to have a bond, so I have to give him a bond. Burglary of the first degree, $10,000. False imprisonment, $30,000. Criminal trespass, $10,000. Battery, $20,000. Best of luck to you, sir. You can leave the booth. Thank you, Ms. Ledette.
Thank you, Your Honor.
All right. Let's see. I've got Dantero Sanders. Dantero Sanders. All right. Sorry, I couldn't see your head there. Position 18, pretrial 22, CP 212388. 648 days without indictment. Unauthorized possession or prohibited item by an inmate and theft by taking. Right now, there is a $1,000 split bond. No bond on unauthorized possession of a prohibited item by an inmate. There's a $1,000 good bond on theft by taking. Trial.
In regards to Mr. Sanders, he's probably in custody for another case. He has 10 prior arrests, open case, 21 SC 179923, hijacking, kidnapping, aggravated assault with a deadly weapon, armed robbery, firearm during, assigned to Judge Richardson. 22 SC 181479, aggravated assault, assigned to Judge Cox. 22 CR 002503C, simple battery. 1 arrest for probation violation. Nothing further.
All right. And I see on the 21 SC that ends in 923, there's a $50,000 good bond. And on the one inside of Judge Cox, the 22 SC, there is a no bond on that one. Go ahead, Ms. Rosenauer. Oh, and Ms. Rosenauer, just so you know, on here, could be very old. There is an outstanding electronic warrant that's on there. If you want me to give you that EW number, it's EW 0176433. And that was issued 6/21/2016, and it's a robbery warrant. Go ahead, Ms. Rosenauer.
Thank you, Judge. Mr. Sanders is 21 years old. He was born and raised here in Georgia. If released on bond, he would stay with his sister, Shanita Jenkins, at 2240 Boulder Springs Road, and that's in Decatur, Georgia. He has a son who's under the age of 2 years old, and that child lives with his child's mother. He was in the 11th grade when he was arrested, and before he was incarcerated, he was working part-time at Wendy's. And Judge, I do want to note he does have a hold out of Henry County, I believe, as well as the 2 indicted cases that pretrial stated. But to my knowledge, he has never been convicted of a felony. I could have missed that. And Your Honor, he does intend to defend himself in this particular case, especially. He did have a cellmate, and so we would need to properly defend that. In respect to the change of circumstances, I know that we're not quite at the 90-day mark for this particular case, but in the interest of judicial efficiency, Judge, we would ask that you would set a bond on this case, since he does have plenty of other things going on. The last thing we want is for him to be held on a no bond status on an unindicted case and have it drag out. So, Your Honor, we're asking for a bond in the amount of $5,000 for this case.
All right. What says the state?
Hang on, I thought he had a bond on this case, Judge.
There's no bond on count 1 and 1,000 on count 2.
On count 2, okay. Judge, the state would note that the offense in this case occurred on September the 16th of 2022, and he does have much more serious cases that are holding him in. Certainly a bond in this case would be appropriate. in the amount that is within the sound discretion of the court.
All right. No drugs unless prescribed, no alcohol, no weapons. You're going to have, once you get out, so first of all, sir, you're not getting out because you got those other cases in there and one of them's in no bond status. But if and when you do, you'd have an ankle monitor paid for by the county with a 24-hour curfew, except for court and to see your lawyer. And you'd also stay out of Fulton County unless you're here for court or to see your lawyer. All right. Count 2 already has $1,000. Ms. Porham, I'll leave it at that. And $50,000 on count 1. $51,000 good bond. Best of luck to you, sir. You can lead a booth. All right. So we got Justice Dozier. Position 20, pretrial 22 CP 206-162, 272 days. Aggravated assault with a deadly weapon. Got a $15,000 good bond. Pretrial.
Judge Dozier, not recommended. 3 prior arrests. All those arrests have been for aggravated assault. Open case 20 CP 191189. Aggravated assault. Nothing further.
All right, Ms. Rosenhuber.
Yes, Your Honor. Ms. Dozier is 30 years old. She has lived here in Georgia her entire life, and her whole family is here. She did lose her apartment since she's been incarcerated in January. But if she is released on bond, I have confirmed with her mother, Samantha Dozier, that she can stay with her at 3215 Cushman Circle. And I'll go ahead and put that address in the chat so pretrial has it. She does have her GED, worked various jobs over the course of her life, even has her CDL license, so would have no trouble getting a job and maintaining that job. Addressing Ms. Dozier's open aggravated assault case, I do want the court to be aware that the victim in that case, not the present one, is actually in custody right now for murder. And the reason that that is relevant, Judge, is that Ms. Dozier was actually present and witnessed the murder of her significant other. And so I wanted the court to know that. And further, she does intend to assert a self-defense claim in that case, as well as the case at hand. We have discussed this case, and without getting too much into the facts of it, Judge, I do think that there would be a viable self-defense claim here. I think there's more to it. But Your Honor, she's been in custody now for 273 days without indictment, without any movement on her case, and she cannot afford her current bond. She's suffering from post-traumatic stress disorder from the traumas she's personally, seen throughout her life, and she has been victimized at the jail. And so, Judge, we would ask for a bond that she's able to afford. Your Honor, in this case, we're asking for a $5,000 good bond so that she would be eligible for the bail project. Thank you.
All right. What says the state?
The state notes that this defendant was sentenced under the First Offender Act on August the 25th of 2017 for aggravated assault on 16 SC 147274. I don't see that has been closed or sealed at this time. So while it's not technically a felony conviction, it's it appears to be an open first offender. And now she's in jail on 2 separate aggravated assaults. Both of which she's got bonds in, it looks like. I see no reason to disturb the bonds as they currently are, Judge.
All right. And where's she going to live, Ms. Rosenhuber?
She's going to stay with her mother at 3215 Cushman with a C Circle, Unit C14. And that's Atlanta, Georgia, 30318.
All right. All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with LARMONTE, last name Harley, HARLEY. Stay away from 2640 Metropolitan Parkway Southwest. You're going to have an ankle monitor paid for by the county. You can leave your house for court, lawyer, and I guess you said employment. So as long as she supplies the name of her employer, the location, where she'll be working. Also stay away from all MARTA. Can't go back to any MARTA station. So, but just supply the name of your employer, location, schedule, things like that, you could leave for employment. This is already count 2 looks like that was dismissed, and count 1's 15, 272 I'll reduce it to $7,000 good bond.
Thank you,
That's
Judge.
part, ma'am. You can leave. All right, now I've got Tyrone Polythres or Poythres. Mr. Tyrone. There you go. All right, position 19, pretrial 22, CP 210900, 98 days without indictment, theft by receiving stolen property felony. There's a $20,000 good bond as of July 23rd. Pretrial.
Judge, Mr. Paul Theris, extensive arrest history, 51 prior arrests, FTA, probation violation, numerous drugs convictions, 1, 2, 3, 4, 5, 6, 7, 8, 9 drug convictions. Last one being a Schedule 1 in 2016. Nothing further.
All right. Go ahead, Ms. Rosenhuber.
Your Honor, Mr. Poythris is 62 years old. He was born and raised here in Georgia. If granted a bond that he can make, he would be able to stay with his sister, Miriam Coleman, at 1651 Bird Street, Southeast. And if he is able to get a bond, he hopes to get out in time to maintain the home that he's currently renting to buy. But if not, then that's where he would be staying. He does have custody of his 2 young grandchildren. They're both 12 and 15. They're currently staying with the next door neighbor, but he's anxious to get out to them and be able to take them to and from school and take care of them. He's worked at Russell Landscaping since 2020, and he would be able to return if he's released on bond. And Your Honor, he does have an extensive history, but he's been very open with me that he does struggle with the drug addiction. I have already referred him to our social worker to be able to link him with resources that he can take advantage of. And Judge, he even completed the RSAT program, maintained his sobriety for 2.5 years, and then did slip back into it. So Your Honor, we're asking for you to reduce this bond to $5,000. It's not a violent charge. He's not a risk to the community. And as with respect to the change in circumstances, it would be this opportunity to take advantage of the substance abuse resources that our social worker can provide. So we'd ask for a bond of $5,000.
All right, what says the state?
Your Honor, at this time, it looks like we're hoping that there will be some sort of substance abuse program that you might eventually qualify for. That's not a change in circumstances. That's a hope. The state would object to any reduction in the bond at this time. Should there actually be a program, then perhaps we could reevaluate where we are at that point. However, there is no reason to disturb the bond at this point. The state does note that the facts of this case are he was driving a car with a broken steering column. There's no question about culpability in this case, and given his history, reoffense is a virtual certainty. The state would object to any change in the bond conditions at this time.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 3601 Martin Luther King Jr. Drive. No further contact with Kendrick Mills, MILLS. I'm going to have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, older medical. He can do employment as long as he supplies the name of his employer, schedule where he'll be working. Of course, if you get him into a treatment facility, he could leave for any sort of addiction treatment or MH treatment, whichever it is that he needs. So previous judge said at $20,000, $12,000 good bond. Best of luck to you, sir. You can lead a booth.
Thank you, Judge. And that concludes my business, if I may be excused.
Absolutely. Did we find Marcus Boyd?
Yes, Judge, he's in 3 North Booth 3.
All right, let's see. All right, Marcus Boyd. Thank you. All right, position 7, pretrial 22, CP 210851, 99 days without indictment, theft by shoplifting, felony, and aggravated assault. No bond as of July 22nd, 2022. Pretrial. Go ahead.
Judge, in regards to Mr. Boyd, extensive arrest history, 79 prior arrests. 1, 2, 3, 4, 5, 6, 7, 8. At least 9 felony convictions. Last one being a 2019 entering auto. He has at least 4 other convictions for theft by shoplifting, 10, 11, 11, and 18. 3 arrests for probation violations and FTAs. Nothing further.
All right. Ms. Pinto.
Thank you, Judge. Mr. Boyd has been in for over 90 days without indictment, so he is of course entitled to a bond. He's lived in Atlanta his entire life. If released, he would live on University Avenue with his mother. He received a 12th grade education. He is 45 years old. So we are asking the court to set a reasonable bond for him of $5,000, Judge.
What says the state?
Judge, it does appear that the victim in this case was successfully put on the, it says the link system, but I'm sure that that's not what it, but yeah, the link, it's the link system. In this case, guess we got to give him a bond. Judge, the state state really has no words. This is a apparent botched shoplifting at a CVS that ends up with a threatening a victim, one of the employees, with a knife. As a condition of bond, the state would ask for a strict strict house arrest, provided that he's got an address. Let me look. Is his address homeless?
No, I just gave you this.
Yeah, well. Strict 24-hour curfew. Leave for help if taken away in an ambulance. Leave for in-person appearances in the court. Nothing else, nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 2429 Martin Luther King Jr. Drive Northwest. No further contact with Chevontie, last name Lewis, Lewis. Stay away from all CVS stores. Stay away from, nope. Okay, I just wrote it down twice, sorry. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, except for court lawyer. The only way you can leave your home, sir. Theft by shoplifting, 10. Let's see. Those other cases, that's 50,000 on aggravated assault. Best of luck to you, sir. You can leave the booth.
Judge, could he have a medical exception?
All right, medical. But he's got to let him know where he's going. He's got to let him know, I got an appointment, so he's got to let everybody do that.
Thank you.
All right, best of luck to you, sir. All right. It's Taylor, last name Taylor. Oh, was that it, Miss Pinto? Absolutely.
Thank you. Have a good night.
All right, Mr. Cho is position 21, pretrial 22 CP 210959. Atiba, I think, Taylor, 465 days without indictment. Possession of a weapon by an inmate, criminal attempt to commit misdemeanor, right in a penal institution. As of 7/26/2022, there is a $30,000 good bond. However, this incident was not 465 days ago. Go ahead, pretrial.
Judge, in regards to Mr. Taylor, he's in custody for more serious offenses, 22 FC 181476, homicide by vehicle, 2 counts, DUI, reckless driving, speeding, driver with suspended license. Judge Richardson, nothing further.
All right, there's like $148,000 good bond on that one. Go ahead, Mr. Cho.
Thank you, Your Honor. Before you use Mr. Atiba, as the court has noted, he has been in jail over a year. And the new incident that he is in front of the court for was around the anniversary of his first incarceration for the 22 SC case. The law is in compliance. It is a high bond. As far as the 22 CP case, it is at 30,000 right now. Your Honor, just based on how things are going, I'll just say it like that. We're asking the court to consider a reduction in half. Mr. Atiba is 29. He's been in Georgia for 16 years. He does have a good address at Maple Valley Court. He has ties to the community, was previously employed. I think 3 cycles total. I'll defer to Officer Bostic, of course. But Judge, we are asking the court to consider reduction based on based on the amount of time in custody. And to be clear, I know that this specific case is not directly related to the original case, but notwithstanding, Your Honor, I would suggest that the length of time in custody has been affecting the jail to some extent. So I'll leave it at that. Thank you.
All right, what says the state?
Your Honor, the state does note that the most serious offense is, of course, the homicide by motor vehicle. That the offense that we're dealing with here was actually a riot in the jail on July the 24th of 2022, earlier this summer. The state also notes that currently the case before Judge Richardson, the homicide case, is scheduled for a final plea and trial calendar on on November the 28th, basically 1 month from now. Judge, the state would object to any change in the bond, as frankly, the only change in circumstance has been that the homicide case, that's the actual case that is holding Mr. Taylor, is moving quickly towards trial.
All right. No drugs unless prescribed, no alcohol, no weapons. If you get out, you have a 24-hour curfew and ankle monitor paid for by the county. You can leave for court, see your lawyer. Count 1, I'll reduce that to 5. Count 2, I'll reduce that to 1. Count 3, I'll leave that at 10,000, 5,000, 1,000, and 10,000. Best of luck to you, sir.
Thank you, Your Honor.
All right, and I got Alexander Williams. All right, position 22, pretrial 22, CP 210769. Alexander Williams, 102 days without indictment. As of July 19th, there is a $20,000 good bond on aggravated assault strangulation, battery, family violence, first offense. Go ahead, pretrial.
21 prior arrests, total at least 11 misdemeanors, couple of FTAs, 2012, 2013, 2000, first offender, felony, only kind of felony conviction. There's a fleeing and eluding obstruction of VGCSA and 01, 8 arrests for probation violation. Nothing further.
All right, go ahead, Mr. Cho.
Sorry. Thank you, Your Honor. Before you is Mr. Williams, Your Honor. As the court has noted, there is a bond, as Officer Bostic has noted. While there is some misdemeanor history, it is that is the bulk of the history that I heard from the court. Judge, we are asking the court to consider a reduction in this case to see if there's been any contact with Ms. Tomei since the arrest date. And Your Honor, we are asking the court to consider a reduction at this time. Mr. Williams is scheduled for a preliminary hearing on 11/2. That is next week. He does have a good address, 197 Conley Road. I did note on the pretrial report there was a hold, but I don't see that in Odyssey. So
Yeah, I did. Oh, wait a minute. There's a warrant in Monroe County.
oh, okay. Judge, if the court would consider as a matter of judicial efficiency to transfer to the other jurisdiction, that would be our suggestion. I don't see it in the jail side of Odyssey, for whatever that's worth to the court, but obviously defer to the court's wisdom and judgment. Thank you.
What says the state?
Judge, the state does note that the victim, Ms. Tomei, in this case, was provided the link for tonight's hearing, but I do not see her on the hearing, on the Zoom call. Judge, domestic violence is always one of those where there is a substantial risk to the defendant. This defendant has a very, very reasonable, in fact, a very low bond at this point, given the fact that this is a domestic violence case and the fact that there is a preliminary hearing scheduled for next week. The state would object to any reduction in the bond at this time.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons. Stay away from 2500 Pleasant Hill Road in South Fulton. No further contact with TYKSHA, last name PTOMY. You're gonna have an ankle monitor paid for by a lawyer with a curfew, 24-hour curfew except for court lawyer. let's see, work as long as you supply the name of your employer and the schedule and exactly where you'll be working. If you get picked up by that Monroe County hold, sir, you have 48 hours to have that ankle monitor placed on your ankle. Another judge already set this, but they said count 1 at 15. I'll do that at 10, and count 2, I'll make that 3,000. So $13,000 good bond. Best of luck to you, sir. You can leave the booth. And Mr. Cho, I think you got a couple bond modifications. Am I right?
Please, Judge.
Judge, the
Yes.
ankle monitor paid for by the county, correct?
Yes, ankle monitor be paid for by the county on that.
Thank you, Judge.
All right. So we got Nadia Batts.
Your Honor, if the court would waive her appearance for today, it's my fault that I dropped the ball. It's my fault. I should have given contact to Ms. Batts, and I clearly did not inadvertently. I apologize. I will contact her with any court conditions ASAP if the court is willing, and no pressure, of course.
All right,
Abide by the court's judgment.
that's position 25, pretrial 22, CP 207-857, Nadia Batts, aggravated assault. She's out on a $7,000 good bond. What I need to know, pretrial.
For prior arrest, no prior felony convictions. Conviction is of disorderly conduct in 07.
All right. Go ahead, Mr. Cho.
Thank you, Your Honor. Long and short, in this case, Ms. Batts is asking for the no contact provision of her bond on the alleged aggravated assault to be changed to no violent contact. The basis for that, in essence, Your Honor, is that we have an excellent attorney in the juvenile division, Ms. Ashley Johnson. She has worked very hard on Ms. Batts's case and has been working to resolve her case in, pardon my ignorance, but I think parent court is the right term. And
Sure.
I apologize. But basically, Your Honor, Ms. Batts has a DFACS case plan. She's doing well on that case plan. Ms. Johnson has provided me all the updates. I can send those emails and information to Deputy White and to the court if the court would like to cut it to the most efficient statement. In essence, Your Honor, part of the family reunification plan, which is what DFACS is wanting for Ms. Batts, is that she will have to have contact with her child so that the part of the reunification can be met. And so the plan in and of itself from DFACS is requesting that Ms. Batts timely modify the conditions of her bond to have contact. That is one of her tasks, I guess, to put it
Right.
to do. And so, Your Honor, she has assessed strength, she has housing, and she has been completing her parental fitness and complying with what needs to be required. DFACS is saying that Ms. Batts and Vanzier need to develop a parent-child relationship with appropriate discipline and supervision. She will need to complete a parental fitness assessment and follow the recommendations. Ms. Batts is resolved to do these things. She does have mental health issues, but she is taking her medication regularly per DFACS report and attends therapy regularly as well. So, Judge, we're asking the court to consider defense's request. Thank you.
All right. So basically, she's needed modified so she can work her plan.
Exactly.
What do you say,
I should
Mr.
have just said it like that. Sorry, Judge.
That's okay.
Judge, the state's familiarity with the DFACS and with this case, going through the notes, she is completing but has not yet completed the assessments and the plans that would allow the gradual reunification with her daughter. I believe the reunification contemplates first supervised visitation and then ultimately unsupervised visitation. She's not there yet. This motion was originally made back in June the 9th of 22. I mean, was originally denied by Judge, which judge was it? Back on June the 29th, or June the 9th of 2022, Judge Drake. she's getting closer, but she's not there at this time. It would be premature to modify the bond as requested by the defense. Once this defendant has is in a position where she's completed what she's now completing, then we can talk about, contact, etc. But we're just not there yet. This motion is premature. The state would object to granting the requested modification at this time.
All right. So when I sit in juvenile court on the bench down there, and here's what I understand. So this is kind of a little conundrum where to work her plan, she's got to have contact. And so some of it to attend some things with her daughter, she'd have to have contact. And she can't have contact. That's kind of she runs into that little speed hump there in the plan. So what I'll do is I'll modify this so that she can have comply with the defects plan and have contact with the child as the juvenile court orders. So as she graduates into being able to see her and have visitation, they'll obviously do that. And if something goes wrong, you can come back and adjust it there, Mr. White. But right now, sure, she's probably not at a place where she can have that contact, but she's got to have the contact to get to the place where she can have contact. So it'll be no violent contact and comply, and she can only have contact as where defects or the juvenile court orders it and working her parental reunification plan. All right, it's position 24, pretrial 22 CP 212087, Cy and East. Got possession of marijuana less than else, possession of Schedule 3, 4, or 5 controlled substance with intent to distribute. There is a split $50,000 bond, and there's a bond modification with Mr. Cho. Pre-trial.
Mr. East, 4 prior arrests, had a hold in Monroe for forgery. June of this year, open case 22 CP 212073, theft by taking, open case in Clayton for theft by conversion and battery. Open case in DeKalb for battery, family violence, and criminal damage to property in the second.
What's up, Mr. Cho?
Thank you, Your Honor. Miss East is on the call. Miss East, if you don't mind turning on your camera if you have one so that the judge can see your face. Judge, this is a bond modification request. In essence, Your Honor, we are asking that the terms and conditions of her curfew be less restrictive. In essence, currently she does have a bond that she has been complying with. Is my understanding. There's no rule NISI or anything of that nature. She's under 24 hours house arrest, basically. And so that is one of the terms of the bond. Miss East has provided to me a letter from her child's school, Ms. Moody. Let's talk about punctuality is the top of it. And it says, in essence, Georgia Pre-K requires that your child be in attendance from 8 a.m. to 2:30 p.m. And they're reviewing September's notices through the management team, and they're letting Miss East know that excessive tardiness or absences will have consequences, I guess is the nicest way of putting it.
Yeah, they do a referral to defects.
Yes. She has a 4-year-old toddler who's in pre-K. She relies on others to help her with the childcare. And the thing is, Your Honor, school is 8 minutes away from where Miss East lives. So that she could, if she were able to have the opportunity, she could drop off and pick up her toddler. So we are asking the court to consider an exception for the curfew or a lift of the curfew. The court has heard there is not that much history. I don't believe that Miss East has gotten in any trouble since the 9/6/2022 first appearance in Superior Court. And Judge, I have additional IALA factors that the court requests. Thank you.
What do you say, Mr. White?
Judge, this bond is what, less than a month old?
Yeah, and she's made it and she's out, right?
I mean, you know, we're 2 weeks, 3 weeks maybe. Certainly, this may be one of the fastest turnarounds, request for bond modifications that, realizing that my experience is limited to only 34 years practicing law, that I have encountered in my limited legal experience. It's almost insulting. The state is opposed to any bond modification at this time. If she's that close to the school, yeah, no.
Is the state's
I
proposal
really have
that
no,
the toddler walk to school unattended because it's so close? I'm just trying to understand the position. I understand that it's a fast turnaround. I'll concede to that, but the alternatives are not available if Miss East is at home because she's under house arrest. I would ask the court. I mean, we're talking about a possession of a Schedule 3, 4, or 5. It's not a Schedule 1 or 2, a misdemeanor marijuana charge, no major felony history. We're just asking for a small modification, especially since the delays in court are so extensive currently. And I do appreciate everyone allowing us to address this today, but Ms. East is doing this, and I do have the paperwork. Ms. East is doing this for her toddler's benefit, I think.
I mean, I don't think it's too unreasonable those couple of weeks, maybe while she was incarcerated, she had somebody to help her. Is she a single mother? Are you a single mother, ma'am? Did you just give me a thumbs up? Saying, okay, so she's got that. I mean, so that means so what we could do is we can make it from like 8 p.m. to 6 a.m. So you have to be home from 8 p.m., ma'am, to 6 a.m. So be home at night, and then you can leave your house at 6 a.m. I mean, you got a kid, so, and I'm sure that you have to do grocery shopping, or what do we make it like 7 p.m. to 6 a.m. That way you can do grocery shopping, get your child, to school, back and forth to school. Don't let me down, ma'am. All right. So we'll change that. It'll still be paid for by the county, but in your own free trial, you got a UJR through free trial. So that way you can meet with them if they go back to meeting in person or whatever they got to do. But that way you can take care of your child. Because if not, you're going to go down this spiral where they're going to be there. They're going to want to take your child. And that's just going to be a mess too. All right. We can do that. So, Mr. Cho, you also had a Frederick Monroe, but I don't think there was a bond modification filed on that one. It was just on there and he made bond. Is that right?
That's correct. Executive Director Hutchinson, I think that's the correct title, did Mr. Monroe a huge solid. We do appreciate the state's effort.
Okay, we got that. Anything else?